Thanks everyone for joining us. This Financial Poise webinar, What Every Founder Entrepreneur Must Know, is part of the Startup Small Business Advisor 2025 series and is sponsored by Max Asset and the National Law Review. Slide 7 of the PowerPoint summarizes this episode, and slides 8 and 9 summarize the series. Speaking of the slides, we will not step through the PowerPoint in any order, nor will you have to listen to us regurgitate any slides. This webinar, like all Financial Poise webinars, is an informal conversation about the topic. You can keep the PowerPoint handy, however, because we may indicate what slides our conversation is touching on as we proceed, so you can take notes. For this webinar, I'm probably going to keep it static on the cover page for a number of reasons, which I don't think you want your legal spend on continuing legal education to learn about. We are joined today, and we have with us as our panelists David Lopez Kurtz. David is a partner at Croak, Fairchild, Duarte, and Barris, which is a full-service firm located in Chicago and Milwaukee, where he focuses on emerging technology, including digital assets, blockchain technology, and artificial intelligence, AI large language models. And David's practice also encompasses traditional corporate and securities matters, business formation, fundraising, mergers and acquisitions, and regulatory compliance. Basically, soup to nuts for any startup entrepreneur. Gary Chodes is with us. Gary serves as CEO of the National Law Review, a top 10 online legal and business news and information source with a 100-plus year history. He's a serial entrepreneur, having founded multiple successful legal tech, legal services, and online business lending businesses. Gary also experienced multiple successful exits for a number of the businesses to private equity firms, insurance companies, and publicly traded strategic buyers. Lastly, we have Michael Weiss with us. Michael is a principal of Weiss Burney, LLC, which is a boutique corporate and real estate transactional law firm in the Chicago metro area. As a transactional legal veteran, Michael represents privately and publicly held entities in business and commercial transactions and handles the negotiation and closing of complex corporate and commercial real estate transactions, both domestically and internationally. He's also a certified public accountant, and his experience includes all aspects of mergers and acquisitions, securities, and corporate governance. I am your host today and moderator, Robert London. That's me. I'm with Jasmine Schlesinger Narendran LLP, which is a full-service law firm in Garden City, New York, which is a stone's throw from Manhattan, New York City. My practice as a transactional attorney spans from M&A to venture capital and startups to executive compensation matters. Basically, anything that's tough to negotiate and fun to draft is what I do, and of course, vice versa. I'm sure you're thrilled to hear all about us, but you're not spending your legal dollars for CLE to hear our infomercials. If you are truly interested in us, you could look at our bios at the back of the PowerPoint deck. This webinar is a production of Financial Poise. More about Financial Poise can be found on slide 59 of the deck. If you're attending this live premiere of this webinar, you can submit questions using the web portal. If you're watching this on demand or have any questions after the webinar, you can send an email at info@financialpoise.com or hunt us down by looking at our bios if you're so interested. Remember, the PowerPoint and conversation we're about to have are meant for general educational purposes and do not replace the need to consult with an attorney, an accountant, or other appropriate professional. In other words, if you are silly enough to take significant action based on what you learned here today, don't come knocking on our doors if things don't work out the way that you would have hoped for. Once again, thank you to the National Law Review and Max Asset. You can learn more about our sponsors on slides 3 and 4 of the deck. All right, let's get this party started. Throughout the discussion today, we're going to chat about various early stage hurdles and concerns where the subject business model will be a quantum computing circuit maker. In past webinars, I selected a somewhat lower tech venture. This time around, because variety is the spice of life, we're going to go higher tech with the goal of having a slightly different discussion than in years and episodes past. So I'm going to start with David. Our entrepreneur is founding her venture with 3 other people. What problems will be addressed by choosing a particular business formation under state law? And what are the principal alternative business forms, if you will, please?
Yeah, so by starting a company and coming together, we have our founder in a position where she's solving for a few different things, solving for limitation of personal liability on her part and those of her partners coming together to found this company. And then they need to solve for how they're going to govern this. How are they going to work together moving forward? What are the rules of the road? And the most typical corporate forms you would expect to see here would be the traditional corporation or a limited liability company. Now, there are a number of different corporate forms, but when we're talking about entrepreneurs who are building, operating companies, companies that are building and doing things, those are the two I'd be most expecting to see.
Okay. Can we warn entrepreneurial folks about the dangers? And we'll go down this a little bit more detail about perhaps having a partnership that's not a limited partnership. What's the difference between a general partnership and a limited partnership?
That's a good question, and that's really why we want to take this. We want our entrepreneurs to take this initial action to limit their personal liability, because by coming together to do business as co-founders, if no other action is taken, you find yourself in a position where you have a general partnership, and general partnerships have a number of issues, the least of which is not the fact that you have joint and several liability between the different partners. And so for any one partner who's going to take an action, whether wise or unwise, the other partners are responsible for the results of that perhaps unwise action.
All right, so that's perfect because, as they say in litigation and cross-examination, none of which I do, you've just opened the door nicely for a follow-up from Michael, which is let's talk about which business forms might be most advantageous regarding limitation of liability and perhaps how flexible or what's the most advantageous regarding management and corporate governance of these types of entities.
Good afternoon, all. Really, the top two entities for liability purposes, well, there's really three, is as David mentioned, the corporation, the limited liability company, and the limited partnership. Limited partnerships, I will address first. We still see limited partnerships when I first started practicing law 30 something years ago, were really very, very popular. Limited partnership is there's a general partner that really controls governance and controls the business. And there's limited partners that strictly invest their money, and they're generally passive. And if they were involved in management, they may be deemed to be general partners, and that was a no-no. And often the general partner in a limited partnership was a corporation. So you had kind of a convoluted structure as far as equity and as far as control and governance. And limited partnerships are still around in the world of private equity somewhat and in the world of real estate, but have really given ground in the last 30 plus years to the limited liability company. Which gives all members is the term for the equity ownership in an LLC. The aspect of limited liability with the ability to be active and govern. And every state in the union now recognizes LLCs with some tweaks from state to state as far as different laws. Delaware is a popular, and the corporation has been around for really, a long time, 100 years, maybe longer. And there you can have governance based on a board of directors and officers, but you could also have officers in a limited liability company. So if it sounds confusing between the two entities, it often is. They're often interchangeable. And I know, many clients I have who are starting up an entity are sort of on the fence. Should I form a corporation? Should I form an LLC? And most lawyers are able to structure governance documents and governance provisions to be about the same for each entity. So it's hard to say between the LLC and the corporation, which is more advantageous, just, sort of in a vacuum. Um, Depending on the type of business, and the type of shareholders, there's probably a checklist of 20, 30 questions. And if they're answered one way, I think the practitioners will lean towards a corporation. Another way would lean towards an LLC. As I think we will find as we progress through today, we'll probably lean more towards a corporation, which are sort of easier and more acceptable in the world of high tech and venture capital. But regarding governance, six one way, half a dozen the other between the corporation and the LLC. Really, it's going to depend on other factors.
Okay, so the way these financial employees webinars are pitched, that they're an informal conversation, like a fireside camp chat, something. I'm going to pretend we're at a cocktail party. We're all a little relaxed. And I'm the entrepreneur, and I come to David and Gary, and Michael's maybe overhearing, I don't know. And I say, hey, I just formed a corporation. Now I can do whatever I want, and I'm scot-free. Panelists, are there any exceptions to that limitation of liability, or is it a silver bullet?
I'll jump in first, and then I would love to hear what David and Gary. There absolutely are limitations to liability. Don't want to go too in detail on this, but there's a theory in every state called piercing the corporate veil, which really applies to limited liability companies. And that means if you're going to do business in a corporate form or an LLC form, you really have to do it that way. You have to be, capitalized to do it that way. You have to follow the rules of the statute. Have meetings, have resolutions. So it and many other things beyond. So it is absolutely not scot-free.
Anyone
Yeah,
else want to chime in? Or you want to rock
echoing
and
that.
roll? Go for it.
Echoing that it's, I mean, it's one of those things where nothing ever gets away with things scot free, right? If it feels like, if you feel like you're able to get a license to kill for a $400 filing fee, you might think a second time about that really following through. A license to kill is much more expensive than that. And so thinking about things that can cause problems, this really comes down to respect. I mean, when you create an entity, you're creating a legal person, and this legal person should be respected, as all people should be. And so, if you are creating this entity simply as, aha, now I can get away with everything I want to get to, that's not respectful to the entity. That's not respectful to what it's being formed to do. If you undercapitalize it, it doesn't have enough money in it to operate and serve its basic continued existence, that's not respecting it. These are the kinds of things that will increase the likelihood that a court will say, no, this is a sham. You didn't create a real legal person that deserves to serve as that intermediary as it relates to liability. We're going to go through that entity directly to you, founder, because you're acting in a way that's disrespectful to the form.
Drat, I'm gonna withdraw my license to kill Esquire trademark filing. Gary, anything you want to add before we push on?
One last playing a little bit devil's advocate. Sometimes when you have an aggressive investor who comes in, let's say you're the founders and you feel you brought in a big hedge fund or other investor to give you capital and help you realize your dreams, and it could turn out that the dreams could turn into nightmares if smart hedge funds and other investors will do things like, for example, use Delaware law, which in particular among states can really limit the fiduciary duties of those investors. So it may not be the acts of the founders, but it could be that if the venture capitalist or hedge fund wants to get rid of management, or upon an exit take advantage of a ratchet or some other mechanism that would potentially put the founders or other smaller investors, maybe they may be the minority investors at the time of an exit, at a disadvantage. Sometimes those hedge funds can really take advantage of the limitations on fiduciary duties. Now, you can't document away things like fraud, but you may be able to be particularly sharp with your elbows. And if people have been paying attention this year in particular, where Elon Musk threatened to leave Delaware with his public company, and Delaware blinked and went back. The legislature came out and made it even more favorable to those controlling shareholders to keep companies filing, particularly the bigger ones and the more sophisticated ones, and the public ones, to keep them in Delaware. So they're, I would say, buyer beware for that founder, particularly when you're getting involved with these bigger investors. And of course, that's why you really need to have a good advice, particularly legal advice, to walk through these kinds of topics.
Great, thanks. So we talked about investors. Let's talk about money, David. Um, LLC versus corporate, which form might be better for attracting capital? Is there any difference income tax wise? Michael, once Gary's jumped in and talked about the basics on fundraising.
Sure, definitely differences. I mean, and it varies in terms of your expected life cycle of the company, where you are in your evolution, the nature of the company, what you're looking to do, when and from whom you expect to be raising capital. If you're an early stage technology company that expects to be raising from venture capitalists soon, you want to be a corporation because that's what the VCs are going to expect. They have obligations to their limited partners who are contributing to the fund that is then being called and given to you, founder, that include not investing in tax partnerships. So, limited liability company with more than one member is by default a tax partnership, and that's something that is precluded by the investment strategy for a lot of these VC firms. They are looking to get qualified small business stock treatment where possible, which again is only going to occur in something that's taxed as a corporation. So that's going to be the answer there. Now, if instead you have a situation where you are coming together with these business partners, using it in that sense, and contributing your respective whatever you bring to the table, your cash and other resources, and you're going to operate and build the company from there, it may make sense from a tax efficiency perspective to be a limited liability company, to be a tax partnership, and to be a pass through in that way.
I'm going to go back to Gary. Let's say, for the sake of argument, we've had our four friends have gotten together to start this new business. But one of them is really the brainy type, and they have figured out how to document their contribution of capital to the company of the IP, and assign the patent and assign all know-how, and like, so it has at least the entity has the foundation for the business plan. Um, how do we deal with, David, um, the other three who, let's say, one might be the CFO, one might be in marketing, the other one might just be the HR, for example. They haven't really contributed anything, yet they're going to be, to a certain extent, maybe not equal partners, but partners from a percentage point of view. How do we deal with their sweat equity? What are, how does one approach it? How is it typically dealt with? Can you chime in on that?
Sure. It's
I'm gonna throw that over to Gary.
sure.
Sure. So I would say, assuming the four partners are at the beginning all feel they're going to contribute equally, except for that uh, intellectual property, then it certainly would be fair and equitable to perhaps have that founder who contributed the IP have their shares, either all of them or most of them, vest right away. And then the others would have to potentially have their shares vest over time, so that if they, if they don't stick around for 3 or 4 years, they might not, in fact, earn all the equity that was they were allotted at the beginning. Whereas the person who had contributed a lot of value at the beginning, in fairness to them, in the absence of others putting in, a commensurate amount of cash or some other asset, it might be more fair to let them have all or most of their shares vest at the very beginning.
I'm gonna stick with you, Gary. Um, what about exit transactions and bumps investing and an acceleration, or, how often, and we'll throw it out to everyone, how often do you see a blend between time served and achieving certain benchmarks? Like if you're in marketing, for example, sometimes you might see a benchmark tied to revenue or something like that. How often do you see that, and should that be something that founders think about rather than just tying it to duration of service?
Uh, yeah, that's a good point. I think when you're at a very early stage business, and let's say like this, if we're talking about a quantum chip maker, it might be a really long time before there are any even sales, right? So tying something to revenue might be particularly difficult, whereas there might be some other milestone, scientific milestone, like how many qubits you can fit on a chip or something. Uh, that's a function of this type of business where maybe the time served might be fair because you're putting in the years, whereas it might be harder to identify what those factors would be. Uh, for other kinds of businesses, or perhaps if you're talking about somebody who's joining a little bit later and they get some equity, you might tie the vesting to hitting different milestones. I've seen it tied to EBITDA, not that atypically, because that's something that the professional investors like to see EBITDA, right? Private equity or other types. Often they're getting their success is based on achieving EBITDA on a multiple of it or earnings. Just having it be on the top line may not be exactly what they want for the founders, but that may be appropriate for the marketing person. So some combination of the two, a performance and a time is not atypical, but again, it would depend on the particular situation.
I would add, yeah, Gary, you're exactly right. I've seen it, and I've structured it according to time, according to, company revenue, different thresholds, individual achievements. And I just want to add, if it sounds complicated, it is, and it can get really complicated. Um, from Series A to Series B to Series C, and if then there's a few acquisitions thrown in, I can't tell you how much time I have spent, and I think David and Gary and Robert, you would agree with me, in a sort of a later stage transaction with a company, just working on revising the governance documents and the equity stack and the executive program. It gets really complicated, really fast as as a company grows, and different interests. And also, very often, yeah, the valuation people have to come into play and help out here because there's models and assumptions, and it becomes like a big calculus problem in many ways. So if it sounds, takeaway to our viewers, if it sounds like it's complicated, it really is.
Um, I'm going to go a little sort of off the reservation here. I'm thinking about the 2026 episode now and fleshing out Q&A for next year. And this is a topic that comes up a lot that I haven't really addressed in the 2 or 3 years of maybe more of doing this, but it's very common when you represent the company or the entrepreneur, they come to you and they say, I just met someone and they tell me they could raise all the capital, but they want 10% of the company and it'll vest upon a successful funding. Uh, I'll 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 single out David first, but you can pass if you want. I guess we can make it a game show. But can you do that legally? What's the world about, paying people finder's fees in, non-public offerings and these sort of informal public offerings, or, you met person who could raise capital for you, but they want a fee, they want equity. We get that a lot. I kind of know what the answer is and how to respond to them, but given the popularity of that situation, I thought maybe we should chat a little about it so I could better craft a dialogue for next year.
Yeah, it's a huge red flag to me. Well, like when I have a founder come and say that, like that's just a massive red flag. It is super common in the early stage technology space. You meet these ostensible experts, and they say, oh, just pay me, and it's going to be this really low, cash retainer, and then on success, I get this other piece. And one, they are unlikely to be registered broker dealers that are selling securities in a way that they are licensed to be selling securities. And two, it's just it doesn't it. I have I have yet to see a single example where I heard a story about someone having done it previously or to go on to do it contrary to my advice and have it work out. I've never seen it. It's always a nightmare. It's always a mess, and I mean, it's not necessarily fraud per se, but it is never a good scene. So if an entrepreneur came to me and said that that's what they had queued up, I would be very concerned for them and would say as much.
I will weigh in also. Robert, that's a great question, and I'm curious to hear Gary's impression and your impression because my whole career I've heard that, and a big caveat here is I am absolutely not a securities lawyer, um, and I know there's been different, no action letters. That's what they're called with the SEC for different types of finders fees. I think in sort of a small business where a few, friends and family are getting together and, someone to help someone raise money and, hey, I want 20% of the company. It seems like that just happens a lot in sort of mainstream America, in mainstream America. But I completely agree with David. Once you get to the whole, solicitation and this money raiser trying to attract institutional money and running around with business plans projections that people are relying on, then all of a sudden I'm dialing up my securities law friends to say, hey, do we have an issue here? And you will often see many of the investment bankers, at least in my world, they're not really taking stock. They just want a cash fee, and that's what they do to make a living. So my impression is, kind of in small Main Street family and friend type of deals, it's just done and seems to be okay. And I don't think it's a real hot button for the regulators. But once you get, playing with the big boys, for lack of a better term, and it's, where the line is really where the rubber hits the road, then I tend to agree with David. It's just not a really good idea. Or if someone insists on doing that, it's got to be absolutely disclosed. And I would encourage people to, get your securities lawyers involved because you may be triggering some of those broker dealer, and other bodies of law.
Gary, you want to chime in?
Yeah, I would say, my experience similar to David is that, particularly if you're looking for any substantial amount of money or professional investors, that, rarely do these things ever work. And what you do find is that the credible capital raisers have the broker dealers. Usually that's a good screen, right? If they don't have one, that is a red flag. The ones that do, they do this regularly. They have a successful track record raising capital. The problem is that generally they don't want to work for pure startups. So it's a little bit of a chicken and egg, right? Because the ones that are credible and have the broker dealer license where you're not going to run into these issues, or it's really a non-issue. A lot of times, like, well, come back in a couple of years when you raise some other money and you need to raise 10 million and you've got some real revenue or profits, and then that leaves you in that sort of, I don't say dark underworld, but you do have the sketchier characters, and sometimes I don't want to say that it never works or that it's never okay, but you're in a riskier zone, and obviously the advisor could be him or herself could be taking some real risk if they raise money and do it the wrong way.
Let's talk about the risk to the practicing attorney. You say, you advise against it. They want to move forward. They still want to work with you. What should the practicing attorney do to protect themselves? Is a memo to the file good enough? Do you say, parting ways because there's securities laws issues with this. My retainer letter carved out federal and state securities law matters, but I'm still uncomfortable. I don't want to proceed. What's the practicing lawyer do there?
I mean, as a securities lawyer, like I would one have a note to the file of like documenting like I told them not to do this times 1, 2, 3, 4, 5, 6, 7, because I'd likely be harping on it, and why, and then it would depend on what some of the other folks on the panel have said. It would be, is this just something where it's like, this is not passing the vibe test, this is a bad idea, but you're willing to disclose it, you're willing to identify who this person is, what they're doing, what the terms are, and we include that in materials that are given to investors. Okay, I don't think that I think that if I get comfortable at the risk there is the risk that the intermediary is taking on being an unlicensed broker, and it is less on the part of the issuer, we could get comfortable and move forward. But if things begin to get, and that's what I see, I mean, particularly early stage technology and specifically in crypto, is like, oh yeah, and you only know me as Avatar 2747, and you won't know my real name, and nobody can know the terms, and I only live in the shadows. Like, no, we can't do this. Oh, well, we're gonna do it. It's like, okay, well then I need to recuse myself from this matter because I can't facilitate you doing something that just screams of fraud.
All right.
I'll briefly weigh in. In my practice, I think I've been pretty fortunate when I've counseled folks against it or to get specific advice. They usually do listen. If not, I put it in writing. I think I've gotten away from just the memos to file because I just never know exactly when that'll hold up, or someone may argue, oh, you never really had that memo to file. So I will, I'm not shy about putting it in writing to the clients, but I know our webinar today is not just about practicing law, but every lawyer should practice somewhat defensively in this space because and get in the right experts, the right legal experts. If it's a securities law issue, bring in a securities lawyer.
Okay.
David
Okay.
also brought up a really good point about crypto. I just think that, crypto, it didn't exist that long ago. So it opened up a whole set of cans of worms. And obviously with the environment we're in right now, it appears to be a little friendlier to it. I think you almost have to put that in its own camp and say, in the world of non-crypto, we generally had sort of a game plan, and it might have been an easier decision. And I'm not a lawyer, but it might have been an easier decision for the lawyer to say, well, where would I, recuse or, decline to work with the client again, or simply, advise against it and put it in the file. I think with crypto, there's just so many more unknowns and risks, including that, secret investor number 7. It just appears to be an accident waiting to happen.
Yeah, and just to sort of echo that and go on to that, there are, not every industry should be basically the same legally, but practically, we know it's not. Crypto, Bitcoin are in some biotech and tech are just a little bit different, for lack of a better term, than your widget manufacturer, where widgets have been, manufactured for 100 years, where there could be problems in businesses like that. But yeah, certainly there are a lot of new types of industry that that are coming up that I completely agree with what Gary and David said, where there are shadier characters. Not that there's not legitimate characters, but it's a lot of the make money fast kind of guys tend to migrate, I think, towards industries on the edge, newer on the edge, where you're either making a big killing right away or losing everything. Not
Yeah,
so in the real estate business generally.
and I'll say, as someone who focuses on being on the edge and emerging technology and where the rules aren't super clear, control the things you can control. I mean, you are obviously a not a particularly risk averse founder because you've decided to found in an emerging and evolving space. Understand it, love it. It's what I do. It's why I get up in the morning. However, because you've assumed this degree of risk inherent to what you're doing, take care of the things that you can that are low hanging fruit, cross the T's, dot the I's, do things as perfectly as you can. And so once you start taking shortcuts, and I think that leveraging this kind of arrangement outside a formal broker dealer sort of structure is a shortcut of doing the hard work of raising capital. It's not for you. It's not there. Maybe we can get away for it to get, the development for the redevelopment of the strip mall down on, 70 whatever. Okay, we could probably make that happen and it's going to be okay. But when you're positioning yourself to be ideally the next big unicorn public company that's going to blow up and change the world in the way that all these things are structured, there's going to be eyes on you now or later if you're doing things right. And you want to make sure that what they see is that you did everything you could to stay on the straight and narrow, even when that path was moving in front of you.
Great. All right. I'm going to use my powers as a moderator to yank us back into the Starbucks where our four entrepreneurs are together. And three of them have just been told they're each going to get 25% of the company. And they go, Michael, they go, yay, we're going to be rich. And then fast forward 6 years later, they say, what do you mean I owe these kind of taxes? And why was it done this way? And why, what are the considerations for sweat equity? What's the planning that can be done? Generally, how would sweat equity be taxed in one situation versus another on exit? What do these people have to think about going forward?
Well, without getting too much into the weeds, a few things. I would tell every business, and I know the panel will agree with me. In addition to getting your legal counsel involved and get your accounting/tax advisors involved right away. There are always, I'm putting on my CPA hat. There's always complicated accounting issues and so forth. Um, if you get sort of stock for nothing sweat equity to begin with, I'm not going to dig deep into it, but there's a tax election that people can get. It's what's called an 83B election. Again, I'm not going to go that deep into it. I know we're not really just focusing on tax. Where basically shareholders can make an election. Hey, I got this stock for free. It's not really worth anything now. I want to declare it as zero value. So if something happens years and years and years from now, I can get this called favorable capital gain treatment versus ordinary income treatment. And that's really, an accountant sort of guide everybody to do this. I think it's important from a legal standpoint, as far as someone leaving the company, or someone, a death, or that the governance documents really have built into it either a corporate shareholders agreement or an LLC operating agreement, some type of buy-sell mechanism. And most of the agreements David and I work on, and Gary's works on, there's some mechanism to allow other shareholders, other members usually, to sort of buy back or to have the company redeem, just another term for buyback, the equity of someone who has to leave the company at some valuation negotiated to keep everything in the house. And, sometimes that's backed up by insurance. This is really what I would call the body of law called succession planning. And, it all goes together. And it generally gets amended and modified over time as the business changes. But it's important. I think the takeaways from this webinar is, get your lawyers involved, get to draft this correctly, get your accountants involved, maybe get insurance people involved, get valuation people involved, to figure out what this company is going to look at like when there's changes of ownership down the road.
Thanks. I'm going to flip over to Gary now. And let's pretend all right, I'm, the lead entrepreneur here, and I understand that I need to staff up. Um, what's typical amount of equity I need to reserve to dole out options and to incentivize the troops to help make this a reality? Is there a range? Is there amount that's too much? Is there amount that's too little? At what time do you make that decision? How's that typically play out? And if I lost Gary, I'll let either David or Michael chime in until Gary pops back. Go ahead, David.
Sure. I general rule, I would say somewhere in the realm of 10 to 20% of the cap table set aside for future hires is within the realm of reason. If somebody says, "Hey, I'm going to set aside 15," I'd go, "Okay, that sounds reasonable. I'm going to set aside 10. Okay, that sounds fine. I'm going to set aside 0. Hmm, maybe we should think about why. Why? What's happening there? Let's talk through it. Um, because you're going to need that. You're not going to be paying full market salaries. You need additional way to align incentives and to bring in the best talent. So that's a little bit of red flag. Come in and say, "Oh, I'm going to set aside 70% of the company." Let's talk through that one too. But somewhere in 10, 20% range is pretty common.
Just to chime in, I completely agree with David, and I see between 10 and 20% all the time. I do think though, and I saw an interesting, completely unrelated ACG discussion yesterday. I do think future trends that percentages may get higher and higher. I think, ever since I've been in practice, the marketplace and investments are really starting to appreciate and reward the workers and the people joining to company. Everybody who signs onto a company, what's my deal? What's my package? What's my upside? Sure, everybody likes cash, but everybody wants to be a part and get equity. I wouldn't be surprised if in time that really grows and changes because the success of these companies are often the rank and file. It's the investors want a return. Somebody's got to do the work. And last comment I would also say something that occurred to me earlier. We talk about some of the other departments, the HR department, the accounting department, um, uh, the guy on the running the chip factory is almost overhead or second class, if you will. But without these people doing all these things, it really, you can't grow your company. It's the devil's in the details. David, always curious to see what you think, but I think I'm starting to notice more and more a company appreciation for that mid management and don't treat them well at your own peril.
Yeah, I think that's right. And I think I'd be less likely to raise an eyebrow if someone came in and said they wanted to set aside 30% of the company for incentivizing people than if they went the other direction and it was smaller. And it's because the competition for top talent is fierce. And when you're a startup, you're not only competing against other startups for top talent, you're competing against the very top of the market. And that's a hard place to be. And every founder either knows that or will learn that very soon. And how are you able to bring those folks in? It's by providing them that ultimate high end upside, which is what your equity incentive does.
All right, Gary, your turn to chime in, and then I'm gonna uh, pick on your experience because you are in fact the only real, true serial entrepreneur on the panel right now. We may all have dreams, but we're still sort of practicing.
So certainly, if you're talking about
But reserving, a portion for equity, how to dole it out for the workforce.
if you're talking about Yeah, my comment would be for the workers, it might be something where the class of units or shares they get would be a little bit different than what the founders got. So they would be benefiting from the increase in the value of the company from the time they get the grant, as opposed to benefiting from day one.
Okay, so we're talking about different strike prices, or for like in an LLC, we're talking about profits, interest, its appreciation of value of when they sign on. It does get the benefit of day one valuation. How about let's talk about the real world, Gary, insofar as putting on your investor hat. What does an investor look at when presented with an opportunity to invest in a startup? Are there certain things and certain attributes that certain boxes need to be checked in order for an investor to write a check? What are some of the true signs of a potential good investment before ink hits the check?
Well, I'd say certainly with something, a startup like a quantum chip maker, I mean, they're going to be looking for, what's the credibility of this team, both in terms of having been successful before with other startups, and even have they, how are these top scientists? Are they affiliated with a, research university? So the kind of things they're going to expect in a quantum startup are going to be, um, you know, a little bit different than if it was, let's say, a retailer or an e-commerce firm, but they're still going to be looking for someone with a track record of success. That pretty much is uniform in terms of any early stage investor.
Okay, so I'm going to ask David to talk to me as if I was the lead founder and basically tell me this is how you raise capital in the real world. And David, when you do that, can you talk a little bit about the pieces of paper that someone like Michael would have to perhaps draft for you to help solicit interest? So let's talk about the real world and the pieces of paper that help make that type of thing happen.
Well, speaking in the real world, and if I'm so I like to volunteer time to speak to cohorts going through accelerators and other sitting through an incubator program, just talking to entrepreneurs. And what I tell them is you need to start raising now. And they'll be like, I don't know what's my valuation? What am I? No. Really, raising in the real world is going to involve building a network. It's going to be going out and talking to people about what you're building, what you're planning on, starting to build those relationships, starting to get good at talking about who you are, what you're doing, why you're doing it, with no ask at the end, other than, can I get together with you just to talk about what I'm working on and to get your feedback? And you begin laying that foundation of having those pre-existing relationships, not personal ones, but professional ones. And that, I think, is a really lacking part in the life cycle of explaining to entrepreneurs what happens. They focus on their product, they focus on their tech, they focus on what's building the team, and like, all right, time to raise, and I'm going to sign up for a lawyer, and they're going to draft my offering documents, and bing bang boom, I'm raising money, and it's like now you hear crickets. Sometimes that's not the case, but it's laying that foundation of pounding the pavement, of going to events, going to conferences, of meeting people before there's an ask. Now, once you're actually raising capital and you're actually selling securities, then there are things that you need to think about, and there are things that you'll be really grateful to yourself for having done. First of all, most capital that is raised in the private markets is raised under exemptions from registration under the Securities Act that require no general solicitation. So you can't go out and say on LinkedIn, hey, proud to announce that we're launching our pre-seed round and message me because we're raising XYZ on ABC terms. Can't do that. You need to be reaching out to people that you have pre-existing relationships with. And lo and behold, you took my advice and you've reached out to a bunch of folks early on and have pre-existing relationships with them and say, hey, by the way, thank you again so much for that conversation we had 6 months ago. We're actually raising now. Do you want to hear about it? So that little practical tip there is to lay that groundwork early, build those relationships early, because it's going to make that subsequent conversation, one, easier, two, more likely to be successful, and three, more likely to be within the four corners of the Securities Act of 1933. Now, when it comes to the documents that you're preparing, a lot of early stage companies, particularly in the tech sector, are relying on very short offering documents. People rely on the simple agreement for future equity, the SAFE, quite frequently. I emphasize short because while the name of that document is a simple agreement for future equity, it's nothing simple about a SAFE. It's a short document, a short agreement for future equity. And what you're selling there is a convertible security. It's a security that gives the investor the right to equity in the future or the right to get their money back in certain circumstances. And so when you're doing a safe round, you're not really looking to hire counsel to draft much of anything for you because it is a form document. What you're really and you should be thinking about drafting counsel to do is to provide you counsel on one, understanding what that document does, two, fielding side letters. As the industry has matured around the safe, since it was first promulgated in 2013-ish, 2015, we get post money, so relatively novel document. The last decade and change, you get side letters. These side letters, some of them are rather standard, but others are quite complicated. And you get these from, particularly when you're raising from VC. So I'm speaking from that angle. And these side letters, this is our quote standard side letter. These are just our standard terms. They often contain very important provisions and ones that aren't entirely understandable by somebody who's just a normal human being that doesn't do this all the time. So that's a big part of where you'll need legal counsel. All of which is say you're raising from sophisticated accredited investors, you're raising from institutional money. The answers all change if we change the facts, and instead we're raising money to renovate the strip mall, and you might want to be able to raise money from your Uncle Bob or other unaccredited investors.
Quick question on safe agreement side letters, because I've seen it both ways. And which do you prefer, or which do you think is more prevalent? I've seen the safe agreement with a side letter, which talks about the valuation cap and or the discount. And I've probably seen an equal number of safe agreements, which are tailored to that investor and their red line. And, we go back and forth on them. And their safe agreement looks different than the 8 or 9 others in the same sort of safe round, if you will. Um, which is better? Which is prevalent? Which do you like?
My preference is going to be if we're going to use a safe, let's use a safe.
Hmm.
If we're going to work on a bespoke document, let's do a convertible note, and then
Hmm.
we'll do a bespoke document, and then we'll have that conversation. So I guess really I'll rewind a little bit and restate what should you hire somebody on the panel or some other lawyer that you trust to draft for you a term sheet. Draft a term sheet and get a formal term sheet that you're using to talk about the deal until you find that lead investor and you start soft circling money. So don't lead with the full investment document out the gate. Lead with the terms. Focus on the business. That's something you're going to understand as the entrepreneur, and that's what the other side's going to understand too, also as a business person. Then lock us lawyers in a little bit. Come back and say, I agreed to these business terms. Make it happen. And that provides less wiggle room and more clarity depending on your perspective. And I think that would be my piece of advice there on a practical level is focus on the business terms, let the legal follow.
Okay. Let's talk a little bit now about angel investors as perhaps being very helpful to a startup's fortunes. Let's say I'm an entrepreneur, Gary, and lucky enough to receive capital, and I've got a bunch of different offers, in front of me. How do I pick one if I don't need all that money? What perhaps can I get from my, angel investors? What could they do for me? What should I consider in choosing as between people who are now uh, throwing money at me, let's say, if we're so lucky?
Well, certainly if you're trying to do something as ambitious as, build a quantum chip, I would say if you can have angels that might be able to make future introductions to the kinds of VCs that would look at something like that, or perhaps a research university or the R&D arm of IBM or Google. So I think in the case of the quantum chip maker, which might be on the one extreme, who that angel may be able to introduce you to might end up being really, really important. On the other hand, if it's a e-commerce firm or a retailer where there might be lots and lots of investors who could give you a little bit of advice, it may not be as important exactly which angel you have, and maybe you simply can spread it around so you have more people to come back to for a second financing. Those are just some initial thoughts I had.
Okay, I'm going to bring us home. I'm going to start with Michael. Let's put aside strictly legal topics here. Give me one bit of practical advice that you could impart upon an entrepreneur, a startup, or otherwise, high tech, low tech, doesn't matter. But one tidbit they could take away from our little cocktail party.
Um, and David sort of alluded to this, is there's no substitute um, for doing it right. This is a combination of more than one tip. I guess it's a multi-tiered tip. Um, get your business plan, do your research, document it great, make a lot of connections, and really go down the middle of the fairway of what the investment community wants to see. I think the VC and the angel investment community is always looking for things a little bit outside the box. I mean, that's the way technology grows. But I mean, I don't know. Let's just take Steve Jobs for example. The iPod, the iPhone, kind of off the wall concepts of course, which obviously have changed the world. But if you study the way he went about methodically, developing it, he was really down the middle of the fairway doing what the investment community wanted to see, and he was connected to the right people who are then more likely to take a chance on you. And I would also add as a sub tip is bring in the right partners and the right expertise in all aspects. And when you are not sure, bring in an operations expert, bring in, really the different aspects of tech. Bring in no substitute for marketing. You need all these players to be successful. And the investment community is going to know that. If you're lacking something, they either will not invest with you and tell you if they're nice enough to help you along, or just not tell you. So have your ducks in order, and there's no substitute. No one gets lucky.
All right. Gary, your tidbit.
Uh, to keep it simple, I would say whatever you think your exit's going to be. So you're at the very beginning and you're with your friends at the Starbucks. If you think it's going to take 5 years, I would probably double it and say it's going to take 10 years, at least 50% longer. So just be prepared for a long ride and be prepared to, have some ups and downs, but have a lot of fun.
David, cherry on the sundae.
Yeah, I'll come back to building relationships, and it's networking is preached to the point where it feels cliche, but there's a reason that it's a cliche. And the networking isn't just for your investors, it's for your legal counsel, it's for your tax counsel, it's for your CPA. Go to events, find the people that are interacting with early stage companies. If you're a founder, you want a professional who interacts with founders and knows what you're going through, and shows up for you in the way that you need them when you need them.
All right. This has been a good one. Thanks again to our sponsors, Max Asset and the National Law Review. Thank you for joining for yet another entertaining and educational production of Financial Poise. You can look for Financial Poise webinars wherever better continuing education webinars are sold. Please join me on June 10, 2025 for the final episode of the Startup Small Business Advisor 2025 series entitled Turning an Idea or Product into a Business. Until then, stay well and stay safe. Thanks again to our panelists. Great one. Have a great one.